Welcome back to the Weekly Friedman, your source for the most essential information in the default industry. Today, we're diving into a significant appellate victory for the plaintiff's bar in New York. In the case of U.S. Bank v. Haber, the court affirmed the lower court's decision, ruling that discrepancies between two versions of the same note were insufficient to create a triable issue of fact. I'm Adam Friedman, managing partner at Friedman Vartolo, and joining me today is legendary appellate attorney, Ronald Lebeck. I feel very fortunate to have Ron here with me today. Ron was a successful litigating attorney in the Haber matter and has extensive experience litigating some of the more complex foreclosure-related issues in New York. Ron, thanks for joining me today.
Thanks, Adam. Thanks for having me.
You know, we've been doing this for a couple months now.
Finally got me to do one.
And the audience has just been anxiously awaiting you getting on here. There's a crowd outside the office waiting for autographs when we're done. Everybody's very excited.
So they heard things.
All right, so look, this is a big win. Do you want to walk us through the relevant facts?
Yeah, it's, I mean, the main facts are plaintiff and plaintiff's prior counsel had previously moved for summary judgment. Actually 3 prior times. We withdrew one of the motions. The second motion for summary judgment was granted and was reversed on appeal for lack of standing. We then moved for summary judgment again and were victorious, and the defendant appealed, claiming that it should have been denied because, one, again, he said we didn't prove standing based on different versions of the note containing different allonges, and that we weren't permitted to make a successive motion for summary judgment. Both pretty good arguments. Both have a lot of appellate precedent behind them. And we, however, were able to establish standing. I don't know if you want me to go.
Sure. No, so let's dig in first. Let's dig in because there's 2 main issues, right? So just to reiterate, right? You're saying the first big issue is that there are 2 different versions of the note, right? And the second issue is that there were successive MSJs being filed, right? So let's deal with the first one first. So there are 2 versions of the same note.
Yeah.
It doesn't sound great. Like it sounds like that could be a problem.
Yes, it's generally a problem, particularly in a case like here in the Second Department, where you can prove your standing by the attachment of a note endorsed specifically to the plaintiff or endorsed in blank to the complaint. That's considered sufficient evidence of standing. And if someone comes and says, no, I have this different version of the note than you attached to your complaint, that necessarily raises a question of fact as to whether or not you actually have the note. Our argument is, well, it may raise a question of fact with regard to whether there's different versions of the note, but that doesn't really matter. For one, we're allowed to cancel or add any endorsement to the note as the owner that we see fit. And 2, really more importantly, you're confusing being a holder of the note with an owner and assignee of the note. I don't need to prove that I'm the holder or that I have it written assignment to me for UCC purposes. I just need to show that I have it. And the fact that there might be different versions of the note was insufficient based on our showing, saying, no, we have it, and here's our business record saying that we have it, and proof that we had it before the action commenced.
Did you have both notes? Does plaintiff have both notes in this situation?
Yeah, it's, I don't know that there's necessarily different versions of the note. There'll be a version with an allonge on it, and then there's another allonge on that, or the note's stamped on one, and the stamp is crossed out in another.
What I'm more focused on in this question, right, is there's 2 scenarios that could happen if there are 2 notes. Let's say in this scenario there's just 2, right?
Yeah.
2 versions of the same note. Scenario 1 is plaintiff's holding both notes. Scenario 2 is plaintiff has one note and someone else has a note. So if a different version of the same note, right?
Right.
I would think if 2 different banks each are holding a version of the note and claiming they have the note, that might give way to an issue of triable fact. Whereas is that right?
Yeah, I've never seen it, and I think that would be something that would be difficult for a defendant to show or prove. But yeah, in a situation like that would certainly raise a triable issue.
So really what the defendant's trying to say here, though, was even if the bank has 2 versions of the note, like they're holding both of them,
right,
that's a problem.
Right. And just to clarify, it's the versions of the note itself, it's 2 different versions of the allonges and of the endorsements. The note itself, same terms, which he doesn't contest and he doesn't deny signing originally, which was one of the factors actually that the court considered in this decision. Was you're not contesting the terms of the note.
Right.
The terms of both alleged notes are the same, other than the endorsements, so
Right, which is interesting because when you first say there are two versions of the same note,
Yeah.
that doesn't sound good. Then when you start thinking about, even when there are two versions, the defendant is not contesting that it exists, is not contesting the terms of the note, is just literally saying, because there are two, we have a problem. Which then, when you frame it that way, it sounds less problematic.
Yeah, and it's going to depend also on what other custodial records the client has.
Sure.
In this case, we provided a purchase and sale agreement in addition to their computerized custodial records saying that I have it on this date, and then you make sure that the testimony fits in with the business records exception to the hearsay rule. And as long as you have that proof in those documents, it doesn't really matter if there's 10 versions of the note.
Okay.
At least that's what my argument, and I think that's what the
Sure.
appellate division found.
Is this a new issue?
We've been seeing the argument a lot more. So, it's funny, but you'll get down even to minutia like staples or hole punches. So if you've attached the note and both the note and the allonge have the hole punch, no one's going to question it.
Right.
So you don't have the hole punch, people question it. So it becomes an issue. It makes it maybe a little bit more difficult to necessarily win a summary judgment motion. Generally an affidavit that would say it's firmly affixed to the note from a client, I argue should be sufficient. Some courts don't find that. They don't find that sufficient proof. I always argue that under the UCC, there's a presumption that any allonge is genuine to a note, and therefore it's up to you to say that it's not.
Let's move on to the second issue. On the successive summary judgment filings, I know that the last few rulings in this district have been that successive filings are improper, but that wasn't the decision here.
Yeah, it's an interesting issue and an issue, quite frankly, that I thought we might lose on. I cite a bunch of cases, and there's significant case law that says if you're moving for a successive motion for summary judgment, it's proper if it's on a limited issue, if it has merit, generally if it's been granted. It has merit, and it limits the burden on the court. And also if it's done prior to filing a note of issue, which is generally when we do it. And there's a whole slew of cases that say that. I think the last one I cite is from 2020 in my brief, and since then there's been probably 3 or 4 that say, now not only can't you do successive motion for summary judgment, it's more considered a motion to renew. So if you want to move for summary judgment again and present new facts, they gotta either be new facts, and you've got to tell me why you didn't provide them in your prior
Dumb this
motion.
down for the audience further. So when we say successive summary judgment filings, we're saying you lose the first one.
Yeah.
What if you can't file another one? What do you have to do?
Go to trial.
So you lose one, you're going to trial.
Right.
Period. Unless I gather, unless there's some crazy new information or.
Right. A lot of judges, they deny it on a limited issue, will deny it with leave to renew, which just is the court saying you can go ahead and file it again, get your stuff together and do it again.
So is this a decision, is this an opening where that might change?
It's the most recent. There's a decision from January of this year that just says, no, you can't do a successive motion for summary judgment. And this says, well, I think what this decision says is, you shouldn't just deny it based on that alone.
Okay.
I don't know if it's a trend in the right direction or I would say in plaintiff's direction, or if it's going to continue to be an inconsistency in the rulings. In this particular case, they do take pains to say based on the particular circumstance of this matter, which is their way of saying, maybe hold off on having a parade on this decision just now.
Look, all in, this sounds like a big win. You had success.
Yeah, I was very pleasantly surprised and very happy.
Oh, very cool. All right, well, look, you're a legend. I wasn't surprised. I wasn't surprised when I heard it. So, all right, look. So normally I give a recap here, but this is confusing. There's a lot going on. Is there anything you could say, and you don't have to explain too much, but if we were to redo this whole video and I said we have 45 seconds, tell the audience what's the most important takeaway, what would you say it is?
Make sure your client gives you the actual most recent updated version of the note when you commence the action, and so that there's no question going forward that there's 2 versions. And otherwise, just make sure they have good custodial records with regard to that. And with regard to a successive motion for summary judgment, go ahead and make it.
Thanks for joining Ron Lebeck and I on the Weekly Friedman, your source for the most essential information in the default industry. If you have any comments or suggestions, please leave them below, and thanks for tuning in.